Okay. Good afternoon. This is Judge Lopez. I'm going to call the 1 o'clock docket, Diamond Sports. Folks, lots of people on the line. I'm going to try to see if I can do this by keeping the line unmuted to avoid hitting 5-star for purposes of today. So I'd ask that everyone please take a look at your phone and place it on mute. I would also ask if everyone, to the extent you want to make an appearance, I'm not going to take the time and do that. What I am going to ask is that everyone go to my website, my homepage, and just go ahead and make your electronic appearance. It'll save a little bit of time, but certainly will recognize that you were here. I do need to hear from debtors counsel. I did sign one order before the hearing. There was a CNO, and I signed that order, and it should have hit the docket. So maybe someone, let me just hear from debtors counsel as to where we are. Someone here on behalf of the debtors? And there's no need to hit 5-star. The line is completely unmuted.
Your Honor, John Higgins, Porter Judges, appearing on behalf of the debtors, and also Paul Weisbein. I think Mr. Parlin is trying to get his microphone functioning.
Okay. Good afternoon. Again, before we start, if everyone again can just take a look at your phones and place it on mute. I'm really trying to avoid muting the entire line, unless you're speaking, obviously. Okay, I'll turn it over. Thank you.
Thank you, Your Honor. This is Andrew Parlin from Paul Weiss on behalf of Diamond Sports Group, LLC, and its affiliated debtors. Apologies for the technical difficulties kicking off. First of all, thank you, Your Honor, and your chambers for being so flexible with us on the lead up to this hearing. I know we just filed revised or an amended interim cash collateral order as docket number 37.
All right. This isn't going well. Folks, again, if I can hear you, please place your phone on mute. I may have to mute the entire line, but I'm really hoping to avoid it. But I'll do it if I have to. Mr. Parlin, I'll give it one last time, and then I don't want your presentation interrupted. But let's give it one more shot. If I mute the line, then we'll just do it. But go ahead.
Okay. Thank you, Your Honor.
Join the meeting.
All right. That was a sign. That was a sign that I should just mute the line. So go ahead and hit 5-star. I don't want your presentation constantly interrupted. Let me mute the line first and then hit 5-star.
Conference muted.
Go ahead and hit 5-star again, Mr. Parlin, just one last time. Make sure I can see you. There you are.
Does that work, Your Honor?
Perfect. Thank you. And I apologize.
No, and we apologize for the just getting your chambers and Your Honor the order, maybe 20 minutes ago. So the bottom line today, Your Honor, is that the debtors, together with the official creditors committee, the first lien group, the secured ad hoc group, and the cross-holder ad hoc group, all have agreed on continued use of cash collateral on an interim basis. The committee, who you'll hear from today, did not file a formal objection, but did have a number of informal objections, and those are all resolved. So again, the debtors, BCC, the 3 ad hoc groups, all have agreed on continued use of cash collateral on an interim basis. There is an outstanding objection or group of objections from Major League Baseball and certain clubs that remain unresolved, and those relate also to the issue that was carried over from last week on payments. Mr. Goldman from WilmerHale will be addressing this and why the debtors believe the interim order that we're presenting today addresses that objection on an interim basis, and we'll come to that in due course on today's hearing. So what we'd like to accomplish today, Your Honor, is pretty simple. We'd like to achieve entry of this second interim cash collateral order. To get there, we propose to proceed as follows, subject to Your Honor's views. First, given how shortly before the hearing the order was filed, what I'd like to do is walk Your Honor through the order and anyone else on video or on the phone. We believe it's important to be tethered to the document, to be grounded in it, and I'll address the entire order other than a particular paragraph towards the end, which addresses MLB issues, and Mr. Goldman, again, will take that up in due course.
Mr.
After
Parlin,
my presentation...
Mr. Parlin, I don't think I have the order. I don't know if it's out.
Well, that's...
But that could be a function of me just needing to hit refresh, but maybe somebody can confirm for me. I don't see it. It might have just hit the docket, and it takes a couple of seconds for it to hit my system.
Yeah. It's docket number 373, whatever that's worth.
Oh, there it is. Got it. I see it now. Okay. Perfect. Thank you.
The document is as notable for what changed as what didn't change. So the red line tells a lot of the story, but not the whole story, as you'll hear from Mr. Alberino as well. So what I was proposing to do is walk Your Honor through it and at a pace that's hopefully efficient. Then Mr. Alberino of Aiken Gump, on behalf of the committee, would like to address the court, the ad hoc groups who also support entry of the interim cash collateral order may want to address the court at that time as well. From there, I'd like to turn over to Mr. Goldman, who's going to address the portion of the cash collateral order that addresses Major League Baseball and the club's objection and the issue that's carried over from last week on payments, and no doubt representatives of Major League Baseball and those teams will want to speak. So that's how we propose to proceed, if it's okay with Your Honor.
That's completely fine with me.
Okay. So we were going to try to share this, put on the screen the order if Your Honor would like us to do so, or I can simply refer to section numbers.
I've got it up. Who would I turn it over to if they were going to put it on the screen?
Megan, are you available from
Megan Young?
Hedges? Yeah, there she is, Megan Young, John.
All righty. No pressure, Megan.
And Your Honor, if you'd like me to speed up or slow down, please tell me and I'll
go for it.
Oblige. Okay, so, just starting on the cover page, the most obvious thing, it is a second interim order. We have the interim order that's in place. As of now, this is also an interim order. That's why it's called the second interim order. There's some ministerial changes up through the first 20 pages, but if we can move to page 20 of the red line, that'd be helpful. Now, Your Honor, most of the changes I'm going to walk through were comments from or resolutions of issues raised by the committee. At times, we got comments from the landlord or taxing authority alike, and I'll note those along the way. Okay. So are we on page, there we go, adequate protection. So starting clause F here, go page 20 to 21. Just the red line here is to note that diminution of values post-petition, and on page 21, you'll see that there's a reservation for the committee and the rights of the pre-petition secured parties as to how diminution of value is to be measured or determined. That's a negotiated solution, so this document does not legislate how the court will later go about dealing with diminution in value or calculating it if and when that becomes relevant, and that was a negotiated point between the parties. If we continue turning to page 23, paragraph 2. Okay, you'll see there, Your Honor, what we're asking the court to grant today. The motion is granted as a second interim order in paragraph 1, and in paragraph 2, objections are overruled other than the outstanding objections filed by MLB, the joinders in the clubs, and the joinders there too. So those are expressly preserved, and for the record. Pending a final hearing, which should, Your Honor, end up granting this motion as entering this order as we're requesting, we will set for Your Honor's calendar. Okay, if we can continue on, please, to page 27. There's a whole series of new text here, Your Honor. What's going on here is that the debtors are in the process of replacing their accounts receivable financing facility. And so temporarily, there's a reduction in liquidity, not to any alarming level whatsoever, but in the original cash collateral order, minimum liquidity was at $225 million. This language here is just to acknowledge that until that facility is replaced, or through July 15th, there's essentially a holiday or an adjustment of that minimum liquidity covenant so that the debtors don't trip a covenant in the cash collateral order and have a termination event. And this was worked out among the debtors and the lenders and the committee. Okay. We can turn to page 29, please. You'll see some deleted text. Your Honor, this is just, again, going back to the diminution in value calculation. Just these things were already mentioned. This is just cleanup. So while it's red, it's not remarkable. And if you turn to page 29, 30, please, Megan, you'll see that we're just clarifying that adequate protection means secure repayment of super priority claims. So just cleanup. So continuing on, we reach an important point on page 30. Hold on a second here. Bear with me. On page 31, this is an important point where I think you'll hear from Mr. Alberino, so I want to call attention to it. In the interim order, out the gate, the first lien lenders and the other lender groups agreed that while the debtors would grant them a lien on the proceeds of avoidance actions, we included a soft marshaling concept. In other words, the value of those liens would only be accessed at the end of the day when it came to diminution claims. The committee will speak to that later, so I won't take Mr. Alberino's role here. But something important to note, that concept remains, but it's subject to entry of the final order. This is an interim order, and it was important for the committee that the interim order remain an interim order until it's final. So you'll see here there's a lack of redlining in the lead up on page 31. The lien on avoidance action proceeds continues to be on an interim basis. The red line on 3132 is just to deal with the landlord consensual resolution. If we keep going to page, I think this is paragraph C on page 33. You'll see, Your Honor, that we're including the committee is getting rights throughout the order. This is an example of it. And the rights are reserved to seek to, recharacterize payments if values are later not what people believe they are today. It's just a different formulation. Continuing on to page 34, please, Megan. This is just there's a lot of language here, Your Honor, just a technical issue for lenders that we don't need to pause on. And we can then move quite a bit forward to page 38 to 39, where these are the second lien adequate protection provisions, Your Honor. They are amended or revised here to match what went on for the first lien lenders when it comes to adequate protection liens, et cetera. On page 42, again, a lot of blue ink. Just to clarify around, second lien agent, revolving lender, agents, et cetera, getting their fees paid, so just cleanup. And as we turn to page 44, please. The committee asked for and received the ability to have committee members reimburse expenses of up to $200,000 for services in connection, for expenses incurred in services in connection with the committee member service on the committee, which was acceptable to the debtors and the lenders. Continuing on to the termination provisions of the order. On page 49. The next two paragraphs, sections 8 and section 9, deal with termination and remedies. What you're going to see here as we move from page 49 on to 50, into 51. Oh, no, actually, I apologize. I'll come to that in a moment. Let's talk about the termination rights. On page 50, some clarification that there's not a termination right if the debtors take out a dip and it repays the 1Ls in full. Mm-hmm. Just clean it. Termination right F on page 51. Again, a lot of ink here. All this does is mimic language and actually repeat language that was already in the first interim order. What that clarifies the termination right is if the debtors do anything that's going to result in the impairment of rights of the first lien parties. This just clarifies if we seek to reinstate the first lien or do something that's not impairment, that can't be characterized as impairment and therefore used as a termination event. This is just to protect the debtors from somebody reading this provision F2 broadly.
Why don't you take me to paragraph 31? Let's just get to where we're... I got all the other points.
Perfect. All right. 31 is, I'm going to leave that to Mr. Goldman, but in short, this is what I wanted to come back to after the committee speaks, is going to talk about what we're doing with funds that would otherwise be payable to baseball or the teams on an administrative claims basis. There is one paragraph, however, Your Honor, if I may, that I want to point out at the end of the order that's very important, and that's paragraph 35.
Well, let's just talk about 31 for a minute, though. And I got it. The committee's going to make their arguments, but is 31 a proposal to segregate essentially all funds that would be payable to the teams during the interim, I guess, until the final resolution of the motion that we're going to decide on May 31st, or is it just, how does this work? I just want to make sure that we're all clear on the record.
Yeah, Your Honor, it's Andy Goldman from Wilmer Hale. Good afternoon, and thank you again for hearing us.
Good afternoon.
So with respect to paragraph 31, the issue, and we previewed this when we were before Your Honor last week, was the question of what's the proper quantum for purposes of 365 and 503 that we owe the teams during the pendency of the case broadcast rights we're utilizing. What we tried to do so that the teams would not be prejudiced in any way was simply to take the full amount of the contract payments owed for each through June 1st and park those in a segregated account. No one would be entitled to touch those, including the debtor, for use for any other reason. The liens of the lenders would essentially detach from those funds for as long as they sat in a segregated account. And then when Your Honor rules on May 31st as to exactly how much we have to pay each team after the evidentiary hearing and the witness testimony is concluded, then we will immediately pay those teams the amount Your Honor directs us to. To the extent that it is the full amount, then the segregated amount will be depleted to zero, nothing left to do. And to the extent that there is overage, meaning we have established that the the 365-503B amount is less than the contractual amount, so we're entitled to not have to pay everything, then that overage will then go back to the debtors for use, subject to the budget, and the liens of the lenders will automatically reattach. This way, for the next 6 weeks, baseball and its teams will have absolutely no concern that anybody can lien up those funds, anybody can take those funds, and to the extent that they can prove up that the contractual rate is indeed the fair value rate, they will have immediate access to all of those funds. It was a way to essentially preserve the status quo while not letting the teams worry that our cash accounts were going to diminish or that our lenders would try to sort of strip away the funds segregated for their use for this very short 6-week period.
So, Mr. Goldman, I want you to think about something, and I don't know. The argument hasn't been presented before me, but I want you to think about something and tell me. I know what. Obviously, I got a good feeling about what the teams are going to argue. So the question I had, and I've been thinking about this for a couple of days now, is I don't know what the spread is between the contract rate and what someone's going to propose as a 503 admin claim, and today's not the day to hash that out. But it seems to me that there is a number that is non-controversial that can be paid to the teams, and where you're not segregating the entire amount, but you're segregating. And I don't want to get into what the true spread is, because I think that's a subject for experts and to come in and argue. And I don't know what the number is, but I do know that there is probably a number where the teams don't have to go until May 31st, essentially, with all the funds sitting in a segregated fund that they're in. I think, and I'd ask everyone to think about it, it seems to me that there is a number that can be paid to the teams, each of the respective teams. And I don't know what that number is. I don't know if it's 30%, 40% of what it is. It's what's disputed. But tell me if that's possible. And again, I'm throwing a concept out there. And I just want everyone to kind of help me think through that issue, because, me putting out a number doesn't make any sense, or saying, this is really teed up for me to say yes or no, up or down. And I'm just thinking between the margins a little bit, but I'm not in a position to know what the right number is or whether that even makes sense.
So, Your Honor, thank you. I assume it will come as no surprise to the court that we have already had significant thought around that issue.
Yeah.
And we're happy to entertain it, and we're happy to think about it. I think with the following caveats, and I think what has given us some pause for concern, and we want to, obviously, we'll take Your Honor up on your suggestion that at some point we take a short recess and talk internally about that. We've also had some discussion I have had with Texas Rangers counsel, who I see somewhere in the video, about that same concept. The question of payment and what we have been grappling with, among others, whether it's 100%, 50%, whatever the number is that we can come back to the court with, I think what we are most concerned about is assurance that if even that number is too high and the teams are required to disgorge, the teams are money good for that disgorgement. Part of the clamoring around some of the pleadings around we need the money to make payroll has given us concern that there may be some credit risk involved, and we can't risk, from the estate's perspective, getting stuck where a team, which we hope would not be the case, and this is therefore more of an ephemeral academic discussion than a practical discussion, comes to us and says, we're in a cash flow crunch, we simply cannot repay you the disgorged overage, if you will, for lack of a better expression. And I think if we could solve for that, then I think the company certainly would be, I think, more comfortable with the support of its various lender groups, and the lender groups that we have talked about this ad nauseum over the last couple of days could probably get comfortable with that construct as well, Your Honor. But we just wanted to bring that to the court's attention.
I thought about that too, Mr. Goldman, and what I didn't want were two things. Were any finding that any number that could be paid to the teams somehow served as any indication of value, so everyone, could keep all their powder dry and argue what they thought the right number was. But in the event that there was some overage, either the teams would have to pay the money back, or the debtor would have a right to offset it against any future payment. So one way or the other. The number that I found would be, I don't want to come up with the number, but any number that's there is either going to get offset against future amounts that would be paid, or the team would have to pay it back, or the parties could just agree on a number saying that, this is the right percentage, and you never even get close to that number. I'm fine with either concept, but I don't want to create a situation where the debtor has paid money to a team, and I'm not saying the situation exists, but I don't want to create a situation where I've signed something or approved or required something, and then force the debtor to have to pay it back. To chase to get the money back. I don't want to create that situation. I'm not saying anyone does, so I'm sensitive to it. So I'll need to hear from the teams about that, but I appreciate that. I know people have been thinking about it. I was always concerned that judges kept things in their heads and never actually communicated anything sometimes, and so I try to get my thoughts out there, on things that I'm thinking about early, so that people have the opportunity to react to them and think about them as well. I think it's the only fair thing for me to do. So, Mr. Goldman, just take it as me just musing along here, but at least giving you an opportunity to think about it up front, rather than hitting you at the back end on something.
Enormously appreciated, Your Honor. I would just note the two wrinkles that we would have to work through are, number one, depending upon how the court rules on June 1st, it may be that we move to quickly reject some of these agreements. So I'm not sure the credit against the next set of payments may work across the board. We'll have to work through that and come back to Your Honor with some suggestions. And then there's a particular quirk with respect to the Texas Rangers, where they have the right upon 20 days notice to try to turn off the telecast rights under the theory that they terminated pre-bankruptcy. We'd obviously fight that and would come before Your Honor on a stay basis. But we may not be able to even get the bang for the buck in terms of the 2 months worth of broadcast relative to their being able to turn us off on 20 days. And so we'd want to work through that permutation as well. But as a fundamental matter, Your Honor, we're happy to consider that and come back to Your Honor pretty quickly on some thoughts.
Mr. Goldman, and let me ask you, and obviously I need to hear from the teams, but assuming the number was the spread, at least as of now, was, I'm making up a number, let's just say it was 30%. Couldn't the teams just receive something like 50%? We never cross the threshold. We never get to the point where you cross the line. Is that even possible?
Yeah, probably, Your Honor.
That's what in other words, I'm open to all ideas, and if there's a deal, I won't stand in the way. But absent one, that's what I'll be looking for. One where we don't trip the wire.
Yeah, and Your Honor, the way we had envisioned this, and I'm happy to digress further or turn it back to Mr. Parlin, the way we envisioned resolving the team's objections with respect today was to deal with the segregation versus payment/disgorgement issue, and then advise Your Honor that with respect to the team's remaining objections to cash collateral, essentially 552, 506, and some reporting, we would deal with that at a hearing, which I think we've scheduled with your chambers for May 4th at 2 p.m. On an evidentiary basis, because certainly Mr. Bromley, representing the Commissioner's office, has told us they intend to potentially take some discovery and certainly require us to put live witnesses on the stand to satisfy the burdens, at least with respect to 506. And so for the remainder of those issues can be, we believe those issues can be comfortably heard on May 4th. We'll obviously brief them. And with respect to the segregation of funds versus payment disgorgement, we're happy to work through those issues and get Your Honor's approval for whatever solution we propose, assuming it is acceptable to the club today.
Okay. That makes sense to me. Thank you, Mr. Goldman. I appreciate it.
Sure.
Your Honor, would you like me to finish the presentation of the order. I think we're just about done with one paragraph.
Since I hijacked it, I apologize. Yes, please.
Right. So just if Your Honor can turn to paragraph 35, it is the last paragraph, but it's not the least important paragraph. What this paragraph does, before I get to the language, it tries to balance the competing interests of the debtors in wanting to memorialize the agreement among the debtors, the committee, and the ad hoc groups that's in this interim order. I believe the first lien lenders and the other lenders are very focused on making sure this order is durable, even though it's an interim order. And at the same time, from the committee's point of view, making sure that the relief granted in here remains interim until there's a final order. And of course, we can't have a final order today for the reasons Mr. Goldman just noted. So if Your Honor takes a look at the language, what it effectively does is it says if the MLB objection is overruled, this interim order, subject to some typographical, edits that need to be made, becomes the final order without further hearing.
Got it.
If there is a change, if the MLB objection results in a change to, not prejudging, 506C, 552, the issues being raised there, then the parties have the right to appear and be heard and address that at the time. But we wanted to, as best we can, have this order, this interim order, be a self-executing final order, if and to the extent or if the MLB objection is overruled when the final hearing occurs.
Okay.
So, Your Honor, thank you very much for your patience in the presentation. Sorry for being
No, and I apologize to you. I interrupted your presentation. I apologize for that.
No apology necessary.
Okay. Before I turn to the... Oh, go ahead.
Mr. Goldman, I just want to say one note before we turn to others.
Oh, sure.
Sure. I apologize. At the end of the hearing, and I don't think this was noted on the agenda, that's our fault. We apologize for it. I think there is some discovery dispute that my colleagues are having with Major League Baseball's lawyers with respect to the timing of reports and production of documents, and I think it was our hope, and I think S&C had agreed with this, that we would bring these questions to Your Honor today. We can certainly save those for the end of the hearing after we can get through the cash collateral and anything else that's on the agenda.
Okay.
Thank you, Your Honor.
Before I turn to the teams, let me hear from Mr. Brimage, the committee, just to get thoughts. Let's see.
Your Honor, this is actually Megan Youngjohn. I just pressed it for control of the screen.
Yep, you got it. I'm muting a couple of lines here. Just ask that you keep your phone on mute. I just really want to hear from, let's see, the committee's around.
Good afternoon, Your Honor. Can you hear me okay?
Just fine. Good afternoon.
Good afternoon. Marty Brimage here with Aiken as proposed counsel to the Unsecured Creditors Committee. Your Honor, I'm joined today by a couple of people I just want to make sure you're aware are on. First of all, Ira Dizengoff, who was not able to make it last week, is making an appearance today. Scott Alberino, who is also joining us, and he'll take the lead today for us. And then last, but obviously not least, Naomi Moss. I would say, Your Honor, that we did file a statement on behalf of the Unsecured Creditors Committee at 12:59, given that this hearing started at 1 o'clock. I promise you we were not testing your speed reading abilities. And Mr. Alberino will go into a little more detail, but that's at docket number 377. And I'm confident you have not had a chance to read it, but he'll walk you through it. And with that, Your Honor, I'll turn it over to Mr. Alberino.
Perfect. Mr. Alberino, have I...
Thank you, Your Honor. Can you hear me okay?
Just fine. Thank you.
Perfect. Interesting hearing today. So, as my partner, Mr. Brimage, told you, Your Honor, we did file a statement shortly before the hearing today. And I wanted to take this opportunity just to introduce a few issues, but I wanted to really, through the statement that we filed today, we thought it was important to kind of bring the court up to speed on a couple of things. Number one was updating the court on where we ended up through our cash collateral negotiations. I know Mr. Parlin stole some of our thunder running you through the markup, but I want to highlight a few things so Your Honor is aware of the contents of the order. And then number two, what we really wanted to do was focus on one of the issues that was not resolved, and we're not objecting to entry of the order here today, Your Honor. But I think given the importance of the issue, and the issue being liens on avoidance action proceeds, we wanted to make sure, wearing our committee hat, that Your Honor was beginning to get up to speed on what these issues are. And I want to make sure that the court is prepared if at some point in the future we're back in front of you on a handful of these issues. So first and foremost, I want to say, number one, thank you to the company and the lenders for working with us to resolve a lot of the issues. There were a handful of what I would call traditional committee issues that we worked through with the parties here. And just to highlight a few, Your Honor, there were multiple kind of reservations of rights on important issues. We provided clarification in the order with respect to reserving rights to contest make-whole claims on the first lien as well as default interest claims. Very importantly, we, on the credit bidding side, we've ensured that the adequate protection liens that are being granted on avoidance action proceeds cannot be credited without a final non-appealable order in place determining the amount of any diminution claim. We did a good job, I think, narrowing the cash collateral termination rights. In addition to some of the customary ones we're all used to, there were some new ones in there, including some termination rights that related to situations where there were material losses or disruptions to the business. I think given the nature of the business, it was important for us to add in carve-outs there for certain contracts that were either going to terminate, expire, or be amended or not renewed during the course of the bankruptcy case, and I think we got appropriate language protecting the company in that regard. We worked with the company to fix the minimum liquidity covenant, which is one of the two financial covenants contained in the cash collateral order, and I think it's set up in a way now where we're not going to inadvertently breach the covenant while the company seeks to refinance the AR loan facility. We kind of rolled back some of the remedies provisions so that they are more customary here in this district. The lenders cannot exercise remedies without filing a motion and getting relief from this court, as opposed to what we had in the prior order. We fully have reserved rights to dispute how diminution claims may be calculated, and that's a concern for us. There was a lot of debate with the community and the lender parties on trying to hardwire how diminution claims will be calculated, given the organizational structure, which is highly complex here, and the fact that there are multiple asset buckets, given how the company is structured, where all the team assets are. But I guess we'll leave that for another day, Your Honor. I think all rights are reserved for all parties. We also worked through a couple of more of the conventional committee challenge issues. We have more time. We've got more money. We've put in place a tolling arrangement to the extent we file a standing motion. And there are certain things that you'll hear about in the future that we're going to have to go through. But I think all in all, I want to thank the company and the lenders for working with us, and getting to the right result. People were responsive, professional, and there was a lot of spirited debate. But I think going forward, I'm hopeful that we're going to continue to work in a very thoughtful and professional manner with one another. But, Your Honor, there was one issue we didn't resolve here, and it was a tough issue. It was a tough one for the committee to swallow. And, the lenders, the company asked me whether we were going to be standing up today, supporting entry of the order. And I was pretty careful with how I chose my words, because in this case, it's hard for me to say we're supportive of a cash collateral order where the debtors have provided liens on avoidance action proceeds to our secured lender parties. But we did get to the order to a place where we are not objecting today, and we're not objecting to entry of the order. We have a deal. We have a deal around the issues that we've resolved, and we've decided to yield on the avoidance action issue. But it's an important issue, Your Honor. And the reason we yielded here is not because we think it's not important, but we yielded on the issue because we recognize this is a very large and complex company with a lot of employees, with a lot of important counterparties. We did not want to, through an objection here, force a non-consensual cash collateral process on the company. The committee's goal here is to support the company, help this company figure out how to restructure and reorganize. We did not feel that it was appropriate at this point to force a non-consensual cash collateral fight solely on the case when the company was not a willing partner in that process. So we made the judgment call. The committee thoughtfully deliberated this, and we decided to take the deal we had, not realize that we would have to kind of lick our wounds on this one and move on. But that being said, Your Honor, the avoidance actions are highly consequential in these cases. You haven't heard a lot about them. We've heard a lot about other issues, and I don't want to diminish, the fight that the company has with Major League Baseball teams. Obviously, everyone is focused on that. There's a lot of pending motion practice, and these are very important issues in the case. But further down the road, Your Honor, we're going to get to avoidance actions. And for Your Honor's benefit, I know I'm just here testifying in court, but you'll hear more about it in the future, hopefully with evidence. But there are a number of historical pre-petition transactions that both the committee and the company are currently investigating. We are at the beginning stages, and the company, through their conflicts committee, is a little bit ahead of us, maybe by a month or so. But Your Honor, there are significant avoidance actions, that relate to transactions involving the Sinclair acquisition, the Diamond entities back in 19. There are significant transactions we're looking at, including more than $900 million of cash distributions from the debtor entities that were used to redeem preferred stock at non-debtor intermediate holding companies that was guaranteed by the parent company, Sinclair Broadcasting. There were hundreds of millions of dollars of payments for management services, and other fees between Sinclair and Diamond that the committee and the company is currently reviewing. There was a partnership agreement between Sinclair, the debtors, and Bally's, where Sinclair received significant value disproportionate to what Diamond was received for the naming rights to the Diamond regional sports networks. And I'm only listing a handful of these, but these transactions, are not inconsequential. These are transactions that could be, worth, north of $1 billion, if not more, to the estate. And while we're not taking a position, Your Honor, as to the viability of any of these actions, heading into this case, everybody knew who was involved in the lead-up to the bankruptcy that there was going to be a big investigation, that releases in particular with respect to Sinclair Broadcasting were going to be an issue. In fact, the funded debt creditors in this case and the company had preliminary negotiations with Sinclair heading into the bankruptcy. People have distanced themselves from those discussions, but the Sinclair releases with respect to these transactions, this will be an issue that is very much one of the front and center issues that the parties in this case in this court are going to have to deal with. So I make this point, Your Honor, because, again, we yielded on the issue. We didn't fight as hard. We didn't fight to the death on this issue because ultimately, if these are just liens, these are just adequate protection liens, they are just diminution claims, and there is more work to be done here. We're hopeful that we are not fighting about diminution claims with respect to the avoidance action proceeds because that's a bad day for everybody on the phone today. But, Your Honor, I do want to note that we are concerned about how these liens could be weaponized against unsecured creditors. I don't know how, I don't know if, but we are concerned about potential weaponization, whether it's in connection with us investigating these claims, whether it's in connection with us seeking to obtain standing to prosecute any of these actions, or if it's in connection with us objecting to any potential settlements between the debtors, third parties, including Sinclair, and some of the funded debt constituencies. But we are on high alert to make sure these avoidance actions are protected for the benefit of unsecured creditors in this case. And hopefully, this never comes to pass. But if need be, we'll be looking to Your Honor to help us in this regard. So with that, Your Honor, that's all I want to say on the issue. I also, if Your Honor is interested, we're happy to talk to Your Honor about some of the Major League Baseball issues. I will note, with respect to the segregation issue in the order, the committee did work with the company, to improve it to ensure that the segregated funds were beyond the scope of the secured lender's liens, to ensure that really there was no stranded administrative liabilities as a result of the company's decision to not pay. But if and when Your Honor is interested, we're happy to share our thoughts with the committee on with the court on some of the MLB issues. But for now, I'll hand it back to Your Honor. Unless you have any questions.
No questions. Thank you very much. Okay, let me hear from Mr. Bromley.
Your Honor?
Yes.
Oh, Your Honor, this is Daniel Eggerman from Kramer Levin on behalf of the ad hoc group of first lien lenders. Can I address cash collateral before you turn to the baseball issues? Thank you. Thank you for the opportunity. And again, for the record, Daniel Eggerman from Kramer Levin on behalf of the ad hoc group of first lien lenders. I will be brief. We are pleased that we've reached an agreement with the UCC on their objections. Notwithstanding that agreement, the UCC filed a statement shortly before the hearing. I haven't had sufficient time to review it, but based on a quick review, suffice it to say we disagree with many of the assertions in there, as well as many of the assertions of Mr. Alberino of a few moments ago. But I do not think it is a productive use of the court's time for me to respond to those issues. We have a deal. The cash collateral order is the product of extensive and good faith negotiations from the weeks leading up to the petition date through just moments before the start of this hearing. It is a fair order. It is consistent with precedent, especially as it relates to liens on avoidance actions subject to soft marshaling. We put that in the order before the case even filed. So we took it off the table. We know that's the preference in this district, and we've served it up. This order carefully balances the debtor's need to use cash collateral to fund these cases and against the interests of secured creditors. The debtor's agreement on these terms are certainly valid. The business judgment is certainly valid, and it's a sound exercise of their business judgment. It avoids the cost, delays, and uncertainties of a contested cash collateral dispute with the secured lenders. We are disappointed that we were unable to consensually resolve MLB's, the baseball's issues, but I guess we can't let the perfect be the enemy of the good. We have a good resolution with the committee, but as you've heard when Mr. Paulin walked you through the order, there's still a number of very important protections in there that we negotiated for that are subject to a final order. So those are important to us, and we'd like to get a final order on those matters sooner rather than later. I understand the debtors have proposed a hearing during the first week of May, and we are supportive of that schedule. So, unless Your Honor has any questions for me, I'm not going to engage in a debate on what could have or should have been.
Thank you. Thank you, Mr. Argument. Does anyone else wish to be heard and supports the cash collateral? Any lender?
Your Honor, can you hear me?
Just fine.
Okay. Your Honor, just very briefly, Scott Greenberg, Gibson, Dunn & Crutcher on behalf of the Secured Lender Group. Your Honor, I'm coming from the same place as Mr. Eggerman. I don't think we should rehash negotiations that happened, but everyone on this phone, obviously minus Major League Baseball and the teams, well, unfortunately we couldn't get to a consensual resolution, spent a lot of time getting to the resolution that's reflected in the order. And I echo what Mr. Parlin said in his presentation when he came back at the end after Mr. Goldman, that paragraph 35 is a very important paragraph, and we shouldn't lose sight of it with the construct that I think we've come up with. And at a high level, what it was really meant to do, right, is you effectively have a deal between the UCC, the debtors, and the three ad hoc groups, and put aside, and I know it's an important thing to put aside, but put aside MLB and the teams for now. I think the rest of us, so to speak, did not want to lose the progress that we made, because we all spent a lot of time hashing out what I think was a pretty commercial deal. And that's the concept that's embodied in the order, right, which is if the court overrules MLB, everyone else is good to go and this matures into a final order, or if there's some consensual resolution, people reserve rights, to the extent it impacts the deal that they negotiated. But along the lines of what Mr. Eggerman said, I don't necessarily agree with some of the commentary from the UCC, and I too did not have a chance, because it was obviously filed right as the hearing started, to read the pleading that was filed. But I think Mr. Eggerman hit the nail on the head. We have a deal, so there's really no point to rehash it in front of Your Honor, other than to echo Mr. Parlin's commentary, which is, paragraph 35 is important to try to preserve that deal between the other parties, and not lose or waste the momentum that we've made among the folks on the phone. Absent the issues, obviously, we still have to deal with collectively with MLB and the teams.
Thank you.
And that's all I had, Your Honor. Thank you.
Thank you, Mr. Greenberg. Anyone else wish to be heard before I turn to the teams? Let's go ahead and get to you.
Thank you, Your Honor. It's Jamie Fidelis of Kirkland Ellis on behalf of Sinclair Broadcast Group. While we don't take a position in terms of the proper allocation of avoidance action between the secured and unsecured creditors, just want to note that we're here and of course vigorously dispute any allegations regarding the size of avoidance actions, and would also note that we are cooperating fully with the debtor's investigation and have provided thousands of documents and have facilitated a number of interviews. And today is not the hearing to get into these claims, but we look forward to defending the claims at the appropriate juncture.
Thank you very much.
Your Honor.
Thank you. Let me hear from the teams. RLB. Mr. Bromley, have I unmuted your line, sir? And if not, can you hit 5-star just one more time? I want to make sure I got you. Can you hit 5-star one more time? Unless you're unmuted. You have unmuted your line already. Let's see there, Mr. Bromley. I think I got you.
Can you hear me now, Your Honor?
Just fine. I apologize.
No problem, Your Honor. Sorry about that. Your Honor, Jim Bromley of Sullivan and Cromwell on behalf of the the Commissioner of Major League Baseball, otherwise known as Major League Baseball, as well as the Cleveland Guardians, the Minnesota Twins, and for today, the Arizona Diamondbacks. Your Honor, we are living in an upside-down world right now, particularly the world that Mr. Goldman has just described, Your Honor. And it's important to talk about what has happened since we were before you. It is Wednesday. We were just before you, Your Honor, Wednesday the 19th. We were before you on Thursday the 13th. And what has happened in the time since we were before you on the 13th is that the debtors have continued their all-out assault on their major partner, Major League Baseball, and its constituent teams. When we stood before you on Thursday, Your Honor, there were 3 teams that had not been paid. The Arizona Diamondbacks, the Minnesota Twins, and the Cleveland Guardians. And since that day, 2 other teams have been added to that list of teams not being paid. That's the Texas Rangers and, through a non-debtor, but still an entity owned and controlled by the debtors, the Cincinnati Reds. So we now have 5 Major League Baseball clubs that are not being paid by the debtors. And for the 4 that are subject to this jurisdiction of this court, there is no relief that has been sought by this debtor to allow that to occur. The only relief that has been sought, Your Honor, is a motion to compel that's been filed by Major League Baseball and the 3 teams that we filed last week, now having been joined since then by the Texas Rangers. That is the only relief that is before the court. What Mr. Goldman has stood up and said is that he doesn't want the debtors to be prejudiced in any way. He wants to maintain the status quo. And then he says, and to the extent that Major League Baseball can prove up that the amounts that are set forth in the contracts are reasonable and appropriate to be paid, then those amounts should be paid. He completely reverses the world. What we're talking about here, Your Honor, is something that Mr. Goldman has not sought. There is no motion before this court. There is not a single word that the debtors have filed with this court that has asked for this relief. They have simply stood up and said that in
But the fact is, all amounts should be paid in full pursuant to the contract rate until such time as these debtors are able to prove and bear the burden, that is their burden, to prove that they are entitled to pay some amount that is less than the contract rate. To do otherwise, Your Honor, would be to, in effect, grant them a temporary restraining order on an application that they have not filed. It simply makes no sense. And we take great offense at Mr. Goldman's insinuation that somehow Major League Baseball or its constituent clubs might not be good for any amounts that are paid to it. Your Honor, Major League Baseball has been around for 100 years. It will be around for another 100. I think as all the evidence so far that is before Your Honor shows, no one's sure that Diamond Sports Group will be around for 6 months. So the idea that we're sitting here and talking about who is at risk, who is being prejudiced, it is Major League Baseball and its constituent teams. And let's look at the calendar. It is April 19th. Between now and effectively the middle of October, Diamond Sports Group is no longer the broadcaster of multiple sports. It is effectively the broadcaster of baseball. It doesn't have any other sports. Hockey and basketball are effectively paid for, and they are winding down in the playoffs. The 14 Major League Baseball teams are the teams that provide the content, that generate the revenue, that allow these debtors to earn a dime. And that's going to be the case every single day between now and the rest of the year. We are concerned, legitimately concerned, that the 2023 baseball season and the broadcast of those games is put at risk by the irresponsible actions of Diamond Sports. And why they have chosen to pick a fight, this sort of fight, of this magnitude, with the supplier of their sole source of sporting programming for the next 6 months is beyond belief. Your Honor, if you look at the cash forecast that is attached to the cash collateral motion, the debtors themselves have said they are going to burn through cash from the petition date to the week ending June 2nd of $201 million. The idea that we're sitting here today debating whether or not we should be paid because there's some chance that the secured lender is going to decide to continue to fund this case is inappropriate and unfair, and certainly, from a procedural perspective, completely detached from what is before this court. We have before us, and before Your Honor, a motion for the continued use of cash collateral. We told the debtors over the weekend and on Monday that we intended to go forward and prosecute our objection today. We intended to cross-examine their witnesses on the stand. As soon as we said that, the debtors backed away and said we want to adjourn. And what did they say? They wanted to adjourn this hearing to the 31st of May and have it heard coincidentally with our motion to compel. We refused that proposal. And only today have they come back without talking to us beforehand and suggested that they want to have it on May 4th. So I'll just say right now, Your Honor, I can't be here on May 4th because on May 5th at 9 o'clock in the morning I have to be before Judge Ambrose arguing an appeal in the Third Circuit. So if we're going to do it, it can't be on May 4th. I want to be present in court. We deserve to be present in court, and it should not go forward on May 4th. It should happen before that. The idea that there are 14 baseball clubs, 16 NBA clubs, and 12 NHL clubs. And of all of those clubs, right now, 5, we are being told, are not, the rights with respect to those 5 are not at market rates. Again, we are being told that, Your Honor, in the context of words relating to a potential objection that has not yet been filed to a motion that we have filed. They are seeking preliminary injunctive relief with respect to the obligations that they owe us under the contract. That is inappropriate. We'll get to the scheduling issue, but on Thursday, Your Honor, you ordered that the debtors file their brief with respect to the motion to compel
on April 28th. And our recollection, Your Honor, is that the debtors at that hearing said that they had an expert, and that expert was ready to file a report on April 28th, and the debtors were ready to proceed on May 2nd. With respect to the discovery dispute, the debtors have now told us they're not ready, that they don't have an expert, and they're not ready to provide us with a report on April 28th. It is very difficult for Major League Baseball to be dealing with, and its clubs, to be dealing with the completely inconsistent positions that the debtors have been taking on a daily basis. Sometimes the positions are changing within the course of a day. It certainly appears to us, Your Honor, that these debtors are flailing. They have no idea what they're doing, and their business plan is non-existent. The idea that we should be standing here and pretending that everything is fine, and we're talking about all of these issues and we're locking down things on a cash collateral order as if the cash collateral order is in the normal course is wrong. Having been through the Sears case and the Toys R Us case, Your Honor, it requires that people stand up early and say, we are staring at a risk of administrative insolvency. That is what we are facing today. This case is burning cash at an uncontrollable rate, and these debtors don't know how to deal with it. And they are putting Major League Baseball, its constituent clubs, and all the fans that rely on these broadcasts at risk. And we should not have to take that sort of risk. So what should be happening, so long as they have the money that they purport to have, they should be paying those amounts to Major League Baseball, to the clubs, and those amounts should be paid currently. The only way, from a legal perspective, that it would be justified in any other way is if they had commenced an adversary proceeding, sought preliminary relief through a TRO and a preliminary injunction. They have not done any of that. They have simply not said a single word in writing with case law, with justification as to why Your Honor should be doing what they are asking you to do. And Mr. Goldman says it in the most cavalier way possible. We are not talking about what the spread should be, Your Honor. If the contract rate is established, the law says that is the presumptive rate. They should be paying the presumptive rate. If they didn't come to court on Thursday of last week with a number in mind as to what they were supposed to, as to what they believed was the appropriate rate, then I think that was inappropriate action on behalf of the debtors. The idea that we were here on Thursday talking about a motion to compel, and their response was, we have an expert, we're ready to present that expert testimony no later than May 2nd, we're going to be able to file it all on April 28th, and now, since then, we've decided to not pay two other teams, and we've decided to tell you that we're not ready with respect to our expert, and we're not going to provide you with that expert report on April 28th. It's simply inexcusable. And we sit here and we hear all of these creditors who are saying, well, you know what, we're in favor of this. We think this is a good way of dealing with it. You know, the RSA, Your Honor, makes it clear that $8 billion of debt are completely worthless, and the market thinks that, and the holders of that debt think that. The only thing we're talking about here is the first lien debt and how much that first lien debt might recover. So we need to stop playing games. They need to stop playing games with our games. This is valuable, unique, exclusive intellectual property that is being broadcast every single day and generating revenue for these debtors and for its secured lender. We should not be standing by and allowing any of this to happen without Major League Baseball's clubs being paid in full until there is a binding final ruling from this court or some other court that some other amount should be paid. So, Your Honor, we object to the fact that the debtors decided to call this a status hearing. We don't believe it's a status hearing. We object to the form of this second interim order, which we had no chance to review in any substance. We believe that paragraph 31 is completely incorrect. There should be no paragraph at all. They should simply be paying us in full. And we do reserve our rights, Your Honor, with respect to everything that has been added to this order. And as I said, to the extent that Your Honor schedules a final hearing on this, we can't do it on the 4th. We will absolutely take discovery from the two witnesses that are being
being proposed, and the fantasy that Major League Baseball and its clubs are not good for any monies that are paid over to them turns the world upside down. It's the debtor with no money in his pocket saying that. So, Your Honor, I will now hand the podium over to my colleague from White and Case, Mr. Loria, who is now involved on behalf of Texas Rangers.
Before I do that, Mr. Bromley, I'm just thinking of all the issues since I've got you here, and I know that at some point I'm going to have to schedule another hearing. I'm just thinking about this. What does your schedule look like the week of kind of the 8th, like the 10th, the 11th, or the 12th? You don't have to let me know now. I just want you to just give it some thought.
Yeah, I think we would certainly prefer it to be earlier than that, Your Honor. But on the 10th, 11th, and 12th, those dates are open for me, Your Honor.
Okay, thank you, Mr. Loria.
Your Honor, can I be heard for a second? This is Daniel Eggerman from Kramer 11 on behalf of the ad hoc first lien group. If you're referring to that week of May 12th for a continued hearing on cash collateral, I will note that there is a milestone in the proposed order that an order is entered by May 8th. And as I mentioned earlier, this is an important issue because there's stuff in there that is not being granted on an interim basis. So that's why we wanted a resolution of it sooner rather than later. Of course, we don't want to handcuff the court. So to the extent we could do it earlier, we would be supportive of that. We would prefer that.
Okay. Thank you. Mr. Loria, let me see if I can find you here.
Good afternoon, Your Honor. Can you hear me okay?
Just fine, Mr. Loria. Good afternoon.
Thank you. My name is Thomas Loria. I'm with White and Case. We represent Rangers Baseball Express in these Chapter 11 cases. RBE, Rangers Baseball Express, is the parent of the Rangers Baseball Club. Your Honor, before turning to paragraph 31 and the questions that the court posed, I'd like to just note that we have a few what I hope are cleanup issues with respect to the cash collateral order. I note that up front that we received it only shortly before the court did. It's 76 pages, and there's a lot there, and there is a lot of new language. I appreciate counsel's explanation. We tried to read along, but there are a few things that I want to bring to the court's attention that I think need to be addressed by way of cleanup. Number one, there is no budget attached to the proposed order. I think it's been represented by counsel that the budget will be the same budget that is attached to the first interim order. I think we'd like to get clarification on that point. And assuming that that's so, I would note that the first budget does not in any identifiable way specify that amounts payable to the teams are provided for. It is also my understanding that counsel is prepared to address that as well. So perhaps I should just pause on that point momentarily and see if we can clear that up front.
Mr. Goldman? Let's see. Mr. Lawyer, why don't you get all your points out, and then we'll let them respond.
All right. Thank you, Your Honor. Thank you, Your Honor. Second point is really more in the nature of housekeeping. Paragraphs 2 and 35 fail to reference the joinder that we filed to the objection, and I would just like to have our joinder specifically referenced so that there's no ambiguity. The issues that we've raised in our joinder will be germane to the final hearing on cash collateral whenever that hearing is held. The final point I would like to raise is that in paragraph 22, as currently drafted, although our challenge rights have been protected, we would be required to actually get standing before May 30th, or our challenge rights would be waived. Now, recognizing that as a general proposition, I think these challenge issues are going to fall squarely in the lap of Mr. Alvarino and the committee, we nevertheless want to be able to have the opportunity to ride along in the back seat should become necessary from our perspective to address particular issues as to our debtor RSN, separate apart from the broader issues that may be the focus of the committee. So in that regard, our request would be that paragraph 22A be modified to basically put the Rangers in the same position as the committee, that we would have until June 26th to commence the challenge action, and that if a request for standing is filed before then, that period would toll until the court would rule on the motion. Otherwise, we're just in a very difficult spot. We'd practically have to file a motion for standing in the next few days, and certainly we have no desire to take that type of precipitous action at this point, or to put the parties to the task of responding. So I'll pause there for a moment, and then we can turn to paragraph 31.
Okay. Hold on a second, Mr. Goldman. I can't hear you. I'm not sure. Don't think I muted you again. Have you? Hold on a second. I see you there.
Your Honor, not to interrupt Mr. Luria's flow, but he did ask me to provide some confirmations on the record. I'm happy to do so now if that pleases the court.
That'd be great.
Thank you. So, Your Honor, in the first instance, it is indeed accurate that we provided a final draft of this order not an hour before the hearing, but we did provide Mr. Luria as well as Mr. Bromley with two prior iterations, and specifically the language in paragraph 31 that we're now focused on today at two different points in the continuum yesterday, just so they could see it and comment on it. Number two, I believe it is inaccurate to say that the budget wasn't attached to the final cash collateral order. Indeed, I think it is. But for the record, the budget that was attached to the interim cash collateral order does provide for the payment for all of baseball's teams, other than the Diamondbacks pre-petition payment through the end of that 13-week cash flow, through the end of that 13-week budget. And as we noted in our pleadings, notwithstanding that, we are prepared to segregate for the Diamondbacks as well. And so I just wanted to confirm that on the record, as Mr. Luria had asked me to this morning when we talked. And then would finally note that if the court reviews that budget, the court will note that our cash balance on 3/17 was $552 million, roughly. Our cash balance on 6/16 we anticipate to be $446 million, and we grow cash and increase our cash accounts after that. So I'm not sure where the comment came from in terms of burning hundreds of millions of dollars, but the budget says what the budget says, and obviously that was prepared by the company's professionals. And with that, I'll turn it back to Mr. Luria for his presentation of that, please, court.
I think he's also asked for some cleanup on paragraphs 2 and 35, adding their joinder to the order. And did you have any thoughts on paragraph 22, adding the Rangers to the standing paragraph?
That's fine. No issues there.
Okay.
Your Honor, this is Daniel Eggerman from Kramer Levin again on behalf of the ad hoc first lien group. I think that's probably more of our issue, and I don't see an issue. I have no problem giving them the same treatment. So
thank you.
We're okay with that.
Thank you. Mr. Luria?
Thank you, Your Honor. I'll continue. I will try to be brief, but I think a little step backwards for a moment to create some context to think about the issues that are before the court today might be helpful. I think as the court is aware, and all of us practitioners who've been at this for a while know, Chapter 11 is a bit of a paradox. And the odd thing here is that the debtor's conduct with respect to the teams seems to be driving right into the teeth of that paradox. On the one hand, Chapter 11 is built around the principle that the preservation of the going concern will maximize value, but it is at the same time recognized that the very act of seeking Chapter 11 relief presents unique challenges and threats to that objective. All of the relationships with employees, customers, counterparties like the teams and the Rangers, lenders in the market in general, are things that are essential to the going concern, are at risk of being destabilized by the act of filing. In recognition of this, the Code provides the debtor with a toolbox full of rights and powers designed to help a debtor overcome these challenges and to aid it in pursuit of preserving the going concern and maximizing value. Some are triggered by the mere filing of the case, the automatic stay, the authorization under Section 363 to continue to use its assets to operate its business in the ordinary course, Section 503, which assures parties who transact with the debtor that their claims will be provided administrative status to give them comfort that they can continue to engage in operation with the debtor post-petition. Further to that objective, local bankruptcy rule 4002-1 specifically requires the debtor to pay its administrative claims on a current basis. There are other tools in the toolbox, though. Paying post-petition or pre-petition wages and benefits to employees, paying pre-petition amounts owed to critical vendors, getting the right to use cash collateral to operate the business in Chapter 11, consensually or non-consensually, getting access to new debt financing by providing the debtor with the ability to offer priority repayment and lien rights. All of these things aren't triggered by the Code, but have to be brought to the court for relief. In furtherance of the objective of minimizing the disruption to a debtor's business that might otherwise occur, we've also developed a time-honored ritual of first day hearings. The debtor marches into court and promptly seeks a series of orders designed to assure employees, customers, counterparties, and the market that the debtor will be okay operationally, that the business will continue as usual, that you can continue to do business with the debtor and not have to worry about getting stiffed. That's what makes the early conduct of the debtors in this case so unusual. The debtors own and operate a conglomeration of regional sports networks. They're in the business of producing content around games played by a set of professional basketball, baseball, and hockey teams around the country, and then selling that content to distributors, cable and satellite companies, who in turn make the debtor's content available to their customers. This is the debtor's business. As it currently exists, the debtor's network gives it geographic diversity. It has a national presence. And because of the diversity of its sports that it broadcasts, it has content to sell to distributors year-round. And yet, Your Honor, despite acknowledging that its lifeblood is the right to create content based on the games played by the sport teams it has contracts with, and despite the reality that the business for the next 5 or 6 months is really all about baseball, rather than doing everything in its power to assure its baseball partners that business will continue as usual, that they can continue to transact in the ordinary course and not have to worry about getting stiff, these debtors have instead fostered the kind of uncertainty about its intentions and prospects that debtors generally fear will destroy value and that could lead to their demise. Prior to and since the commencement of these cases, these debtors failed and refused to provide assurances or comfort to their baseball partners that they will perform their obligations under their baseball transmission rights agreements. This uncertainty, combined with our RSN's obvious insolvency prior to the bankruptcy, led the Rangers to believe a pre-petition termination notice to our RSN was appropriate, and we sent that notice. We were concerned about whether our games would be available for broadcast to our customers, that we would struggle to pivot if we had to in short order to a new broadcast platform. We were concerned that our RSN might try to continue broadcasting our games without paying us for the privilege. But unlike so many other debtors, instead of promptly taking action to stabilize things in Chapter 11, they've actually caused uncertainty to continue, if not get worse. They started selectively not paying certain teams for their content, despite continuing to use that content in the ordinary course post-petition. And as this behavior unfolded, it caused Major League Baseball, on behalf of its teams, who have in fact not been paid post-petition, to seek relief. Pay what you owe pending your decision to assume or reject. We have joined in that motion. In response, the debtor said that the fair market value of the content is worth less than the amount owed under the contract, and asked for a hearing to try to prove that. Didn't come forward with any evidence, and in fact, those statements were contained in an objection to a motion for emergency consideration of the motion to compel. But instead of continuing to pay pending the court's determination, instead of offering to pay what they thought was fair value pending the court's determination, which they now admit they don't know, they simply stop paying. Now, Section 365 is a powerful tool in the debtor's arsenal to preserve its business and maximize value. But it's not that powerful, and it doesn't provide for this. It gives the debtor the right to assume executory contracts it believes are beneficial, even contracts that were in default pre-petition. It gives the debtor the right to reject contracts it believes are burdensome. But whether it assumes or rejects, it has to do so cum honore. The debtor must assume or reject the entire contract and all of its rights and obligations. It doesn't say that you can simply not pay while you decide. Actually, it does say something like that with respect to equipment leases, but not executory contracts. I'll come back to that in just a moment. The code clearly contemplates that the debtor will perform its post-petition business obligations in the ordinary course, all of which constitute administrative expenses. Executory contract obligations, including those arising under pending contracts that are pending assumption or rejection, are not carved out from this, unless the debtor can establish that the fair market value of what it's receiving under an executory contract is less than the contract rate. But it is not for the debtor to just unilaterally reset the price term under its executory contracts post-petition, or to just decide that it's not going to pay what it receives under its executory contracts post-petition. Your Honor, imagine the chaos. Well, actually, you don't have to imagine it, because that's what's unfolding here. The debtor did not bring an action to determine the fair value of what it's receiving under its TRAs with its baseball partners. The debtor did not seek or obtain an interim order authorizing it to pay a lesser amount on an interim basis until it can litigate the issue of fair market value. Rather, the debtor just unilaterally and selectively so far stopped paying. This is not only inconsistent with the principles of the bankruptcy code, it's imprudent. If the debtor believes it has transmission rights agreements that are burdensome, the debtor can move quickly to reject in order to relieve itself of its ongoing obligations. That happens all the time. And if it believes it will be delayed in getting court permission to reject, it can seek interim relief regarding the contract's pricing under the theory that the counterparty's administrative expense claim is limited to the fair value of what it is providing the debtor. The debtor has so far chosen not to avail itself of those rights. Instead, it is just unilaterally withheld payment. Importantly, the debtor does not assert that the transmission rights agreements with its Major League Baseball partners are equipment leases. Obviously, they're not. But that's important because, as I previously mentioned, Section 365B5 specifically gives a debtor a 60-day breathing spell to not pay post-petition obligations. And it provides a roadmap for the debtor to seek to pay less than contract thereafter. 365 provides no similar rights with respect to executory contracts. The fact that Congress specifically provided that right for equipment leases means that, as a matter of statutory construction, that right does not exist with respect to executory contracts where the code is silent. Unless and until the court determines otherwise, the debtor has to pay current for what it receives post-petition under its transmission rights agreements. Now, I heard counsel for the debtor talk about concern with respect to risk. I've got 3 points I'd like to make with respect to that. Number one, I've never heard a debtor say that it's not paying its counterparties post-petition because of risk that it won't get repaid. Number two, debtors usually make exactly the opposite argument in their critical vendor motion. They say, Your Honor, if you don't let us pay these creditors, these key trade partners of ours, they may fail, and that could hurt our business. Interesting that the debtor isn't thinking about that here. 3, most important, we're talking about multi-billion-dollar businesses. I'm sure the court is familiar with the valuation of professional sports teams. It is implausible to suggest that the owner of a Major League Baseball team is going to allow his business to go into bankruptcy over what is a small amount of money, a few $1 million perhaps of overpayment that has to be disgorged. I can't speak to the balance sheet and the liquidity of any of the other teams, but I can assure this court that the Texas Rangers have all the liquidity they need to meet any such disgorgement obligation were that to be imposed as a consequence of the court's subsequent ruling. And you know what, Your Honor? If by chance we didn't have the cash on hand, we would do what we did during COVID. We'd make a capital call. And the people who own this team, who are investors in this team, this multi-billion-dollar asset, would answer. The risk of non-payment is nada. It is zero. That is a Trojan horse. What the debtors are really doing here is trying to use non-payment to extract concessions out of the teams in Major League Baseball to which they are not entitled. Now, is there a deal to make at some point in time in this case? I'm sure there is. But it's not going to be achieved by twisting people's arms. The amount in the big picture that the debtor is worried about here, the difference between contract rate and fair market value, is de minimis at best in the big picture. And indeed, we intend to come forward with evidence on the 31st demonstrating that, if anything, the fair market value of our rights is greater than our contract right. Let's see what happens then. Your Honor, we're receptive to the idea of trying to find peace. Peace is good, but the debtors just have to honor their obligation. They have to pay their administrative expenses as they come due, as contemplated by this court's local order 4001-2, and pay what they owe to the teams until and unless they get relief from the court that authorizes otherwise.
Thank you. Let me hear any response. Oh, let me ask, does anyone else wish to be heard before I turn it back over to the debtors? Let me just check. Mr. Goldman.
Your Honor, I will be brief. I appreciate Mr. Lauria's comments and look forward to litigating those issues when we come before the court properly on May 31st. I would just note a couple things for the record. I appreciate the nada, zilch, no chance of any credit risk. But unless I am misremembering, I think two of Major League Baseball teams have filed for Chapter 11 in the last 15 years, and I think, unfortunately, one of them was Mr. Lauria's team. So there is always credit risk. However, unlikely that credit risk is from a lender's perspective, and here we would be serving in that capacity. Number two, to comment on what Mr. Bromley said, it is their burden as administrative expense claimants to come forth and support the quantum and entitlement to their claim. Is there an overlay of a contract? Is the presumptive fair value? Yes. Is that a rebuttable presumption? Yes. We will deal with that on May 31st. But it is every administrative claimant's burden under 503 to prove up their claim. All we're looking to do is, as expeditiously as we can, have those claims proved up. Once those claims are resolved, and I think Your Honor indicated that you would be prepared to rule on the 31st of May. We hope that's the case. And whatever Your Honor tells us to pay, we will pay. We're not looking to build cash to be able to pay and use that as an excuse. We are prepared today to segregate the full amount. And yes, Your Honor, we're also more than amenable to taking a short recess so we can talk about a proper quantum of what we would pay now subject to disgorgement with these four teams. Either is fine with us, Your Honor. We haven't had that opportunity yet because oral argument is continued, but at some point would ask Your Honor for a recess so we can come back and offer up a proposal that we hope satisfies the court's short-term concerns. With respect to Sullivan and Cromwell's remaining objections, whether it's May 8th, 10th, whatever the date is, Your Honor, we will be prepared to deal with the objections raised, 506, 552, and access to informational documentation. So we will be able to address all of those at that time. And again, Your Honor, all we are looking to do is satisfy our constituencies that we are essentially getting the fair value for what we are broadcasting for a very short period of time. And indeed, we're talking about 6 weeks from now to the finish line in terms of a May 31st hearing. And if the clubs are as well heeled as they are, or say they are, I can't imagine that a 6-week hiatus is going to disrupt anyone's ecosystem. With that said, unless Your Honor has any other concerns, I'm happy to yield back the podium.
Now, I'm going to grant interim use of cash collateral. I believe it's appropriate. No need to go forward today. There's agreement with the lenders, and I appreciate very much the hard work that the committee has done. In a relatively short amount of time. You can clearly tell they've done an incredible amount of work and really dove into the case, and so I very much appreciate the work of the committee. It gives me comfort that the process is working. I think let me just say, as to the next hearing date for that, I think Mr. Bromley, I'm not going to. I think you have a right to be here, and you have a right to be here in person. And so I'm going to ask Mr. Eggerman. Y'all can think about it. May 2nd would work for me, but if not, and I don't know if that works for you, Mr. Bromley. I'm just throwing out a date before that time, but I don't want to jam you on the 4th or the 5th. I think you got an incredibly. I don't know what you've got. I have a suspicion, but I don't want to be on me today. If you can't make it on the 4th or the 5th, then you have a right to be here in person, and that's what you want, then then the 10th, the 11th, or the 12th would work for me. The 8th and the 9th, I just can't do. Unfortunately, those would, so it could be the 2nd, the 10th, or really the 12th would be the better dates for me. In the 12th is pretty wide open right now. But I remember somebody couldn't do the 12th, which is why we moved the hearing to the 31st. Either the 12th or the 19th. We were having issues with those dates. And so I throw the 2nd, maybe the 10th out there for parties to have I am prepared to rule. I will be on the 31st. And we're not going to move that date. unless there's an incredibly good reason to do so. On the 31st, I'll be prepared to go. And I think in terms of having the expert report, I'm going to require the debtors to file it by the 12th, May 12th. We push the entire dates out. I think they can trail. Any expert report would have to be filed by the 12th. That'll give parties roughly two weeks to have it and prepare if they need to take depots or anything. As for paragraph 31, let me just back up for a second. I believe I'm still going to need a revised form of order to accommodate the statements and the comments made by Mr. Lauria, the inclusion of those, which Mr. Eggerman, you've told me you're okay with. Debtors have told me you're okay. I'm going to assume that's good enough, that someone can get a revised form of order to kind of do what we call the cleanup. That was to the preamble to add the objection by the Rangers, paragraphs 2 and 35, adding their joinder there as well, and then the tweak to add the Rangers in standing on paragraph 22. Those are the ones that I wrote down. With respect to paragraph 31, I'm going to give you all a short recess if you want one. And I'm really encouraging you all to come up with a number or a percentage. If not, I'm just going to pick one. And you're going to leave it up to me with the limited knowledge that I have, but I'll just pick a number. I don't have a great concern that the teams wouldn't honor any order that I have. So I don't think that's a great concern for me, and I certainly understand the concerns that the debtors raised, but the teams are represented, and the MLB's here. They're represented by some of the best lawyers in America. They wouldn't make. I'm gonna hold to their representations, and I'm really. Y'all can work on an order that provides the teams some payment. And again, I don't want it to be used. I agree, and I share the concern that Mr. Lauria raised. It shouldn't be used as, what I'm asking the parties to talk about really shouldn't be used as a negotiating point, either to set a floor as to what parties are thinking and to be used as what the price should be. And at the same time, it shouldn't be used as a leverage tactic as well to withhold as much cash as possible in the hopes of seeking concessions. There is a number that works. You all know much better than I would, but really, if you come back to me, I'm just going to pick a number, and I'm hoping that you don't leave it in my hands. But I'll be prepared to come up with one if that's what you ask me to do. That way, I do think provide some relief to the teams. Again, I'm not concerned about their financial stability. What I am thinking is normally this is what we would do anyway. In any case, pay the uncontested and reserve for the disputed portion of it. That's the way I'm thinking about it. So again, y'all can tell me if you want me to get back on, or you can make the tweaks, circulate it as you need, and then contact my case manager and let me know if you're ready to upload. The concept of an interim automatically turning into a final, I'm fine with it, but obviously if somebody wants their day in court, they're going to have it. So I'll give you all an opportunity to take a look at your schedules, talk about the dates, either the 2nd or the 10th. Leave it up to me. I'll just pick one. And I realize that may require some additional conversations from the lenders, and I'm sensitive to that. But unfortunately, I'm just out the 8th and the 9th. I just can't be here, and so that's what's driving that, Mr. Hagerman. Other than that, I would have bent over backwards to be here. I'm only saying that because I literally just will not be here, and I can't move it. What I have to do on that date. So other than that, I would have moved whatever I needed to. This is important enough. So with that said, y'all can tell me how much time you think you need, or or how you wish to proceed. Mr. Goldman?
Your Honor, if I may, can you hear me?
Just fine.
Great, thanks. A couple things. Number one, I am informed that Aiken Gump is not available on May 2, which would suggest, given Your Honor's prior comments, May 10, which we're happy to consider and works for us. I would just want to step out briefly and make sure that both of our witnesses are not on.
Mr. Goldman, or the 12th, and again, my recollection could be wrong, but there was someone couldn't make the 12th, or there was an issue with May 12, and maybe I'm just remembering that wrong. But if I am, I'm here that day, or May 11th in the afternoon. If somebody wanted to do it, I would make it work. So somewhere between May 10 and 12, why don't you use that as the parameters?
We will. And Your Honor, if I may, I would like to ask my partner Ross Furstenbaum to address the court on what is, I think, a discrete discovery issue. I had previewed this at the beginning of the presentation, and I know that I think Sullivan and Cromwell and perhaps White and Case want to weigh in on that as well. If I may just turn the podium to him just momentarily.
Sure.
Thank you.
Thank you, Your Honor. Can you hear me okay?
Just fine.
Great. For the record, Ross Furstenbaum from WilmerHale on behalf of the debtors. Your Honor, Mr. Goldman previewed the issue here. Unfortunately, we've been unable to reach agreement with Major League Baseball and the movement teams on a schedule that gets us to the May 31st conference. I think the key issue that has sort of triggers the dispute, it has to do with the timing of the service of expert reports. I think Mr. Bromley made two inaccurate statements in his presentation about what has been said so far.
Mr. Furstenbaum, does May 12 work? Does that solve the issue?
So, Your Honor, I did hear Your Honor say about May 12th, and we can, of course, if Your Honor orders us to serve our report on May 12th, that's fine. However, the dispute has arisen in two respects. First, we had a schedule we had proposed to Major League Baseball, and the team has provided for simultaneous exchange of expert reports. The movements in response have taken the position that we should serve our expert report first, and they should serve an expert report second. In negotiations, we have said that we would be okay with that so long as that schedule would not prejudice us in any way. And the prejudice that comes with the schedule that Major League Baseball...
Mr. Furstenbaum, you just went mute. Hold on a second. Let me see if it's you or something I've done here. Mr. Furstenbaum, you're on mute. I can't hear you. Something has happened. Mr. Brimage, can you hear me? Nobody can hear me, huh?
Your Honor, Daniel Eggerman from Kramer 11. I can hear you.
Okay. Okay. Mr. Furstenbaum, can you hear me?
Your Honor, I just got out of information. I just alerted the Latham team that we can hear them. What was it working on it?
Hold on a second.
Can you hear me now?
I can. I apologize. I don't know what happened. I'm muting one more line here. Don't know what happened.
No. Apologies, Your Honor. That may very well be an issue on our end. Your Honor, I
That's the last thing I heard. Why don't you pick up with you had offered to allow a separate dates as long as it didn't prejudice you. So what did you have in mind?
Correct. So what we had proposed in terms of separate dates was that we would submit our expert report on May 19th, and they would submit their expert report on May 23rd.
And we did that because it was the move-in's idea that there be a round of expert depositions that takes place in between the expert reports and the final hearing. If the move-ins would like more time for their responsive report, we're happy to take the depositions off the calendar. Frankly, I'm not sure that they're necessary. Both experts will be cross-examined at the hearing, and both sides will have each other's reports to work from. And so we are not trying to jam up the move-ins in any way by having an insufficient amount of time to do what they need to do with their expert report. But what we are trying to avoid is prejudice where our expert has to serve a report and be deposed before the close of fact discovery, exchange of documents, and the taking of deposition.
When is the close of fact discovery?
So what we had tentatively agreed to, but again subject to getting the expert reports worked out, was that fact depositions would be completed by Friday, May 18th. I think that's a Thursday, May 18th. That our expert report would then be submitted the next day. So we're just asking for a day after the close of fact discovery, May 19th. And then if they want to serve their report on the 23rd and then have expert depositions, we were okay with that, but we think the better course, frankly, would be for them to serve their expert report, no later than Thursday the 25th, and that we go right to the final hearing on the 31st. And that would give us enough time to review their report.
I'll tell you what we're going to do. I'll make this easy on everyone. I want debtors' report by the 15th. The responsive expert report can be filed by the 18th. Y'all can take depositions the week of the 22nd, and we'll come in on the 31st. That's what we'll do.
Thank you, Your Honor.
All righty. How much? Again, I think you can hear me strongly encouraging the parties to do this. I can pick a number, but it's not going to be as meaningful. Up to y'all. Everything else is worked out. Take as much time as you need. I'm not going anywhere. Just let my case manager know what y'all want to do. Maybe we'll check in with you all at 3:30 and just see where we are.
That's fine, Your Honor.
Okay.
Yeah.
And if something works out before then just email my case manager, and we'll essentially cancel the remainder of the hearing once I know if there's an order that's going to get uploaded. If not, we'll come back on and we'll continue. Okay?
Thank you, Your Honor.
Thank you.